We are back on Morning Line. Thanks for joining us on this Monday. Great show this morning. The question of whether or not someone is sane or not, if they're competent to stand trial. Two very high-profile cases we've been dealing with locally here, and those involved with determining that. Dr. Kimberly Brown is with us this morning, forensic psychologist from Vanderbilt. It's great to have her on. I could talk to her all day, and I appreciate you coming on this morning. Yeah, Dr. Brown, just as you kind of laid out in the last segment, the difference between competent to stand trial or not competent. How is it when you're going through the evaluation process, can you determine and be convinced that the individual you're evaluating is not faking it?
Yeah, this is like the million-dollar question. This is a big question. It's the question that every prosecutor will cross-examine an expert on. How did you know they weren't faking, they weren't fooling you? And it's something as forensic psychologists we're very vigilant to. So we're always concerned about whether someone is not putting forth their best foot and is presenting themselves as having more symptoms or exaggerating symptoms that they have. So a few things. The big thing I would say is consistency. So if we're looking at people who are faking mental illness, they lack consistency. So they may not be able to keep up the act the same way across time. So they may act one way when they're being interviewed by me, but a few minutes later, when they're walking back with the jail officer to their cell, they act very differently. And this is why forensic psychologists need to gain access to as much information as possible. And this goes back to those different pieces of data or the different puzzle pieces that I referenced earlier. We don't just rely on the face-to-face interview with someone because that can be misleading. The other thing is we look at consistency between what we're seeing and what's been documented, oftentimes in extensive hundreds of pages of records that these individuals often have from previous treatment when they were not involved in the criminal justice system. And so we can look at the consistency of their symptoms between those presentations. And finally, people who are exaggerating or malingering symptoms, they tend to overact the part. They tend to be more dramatic in their presentations. They tend to try to call attention to their symptoms. And oftentimes they present with symptoms or combinations of symptoms that are unusual or atypical or just not often seen in a clinical population. So we can compare our knowledge to what genuine clinical presentations of these illnesses look like. So we know whether the presentation we're seeing is potentially suspicious for malingering. And then finally, we do have psychological assessment measures that can formally test to see whether somebody may be distorting or exaggerating their responses. And we have some objective measures of that as well.
Interesting. All right. Before I have a follow-up, we have a phone call for you from Ann, who I know followed one of the trials very closely. Good morning to you, Ann.
Good morning. As with the Waffle House trial, just as an example, myself, and I'm sure I'm not alone, wondered how far back you could go to examine records on the defendant. How often are clinical psychologists or the people making these evaluations able to go back on defendants to examine their high school, their junior high, their early childhood medical records? We see the trials and we wonder why this evidence isn't brought into the trials, but obviously these things have an impact on the decision on whether or not these people are criminally insane or able to stand trial. And just as with this latest trial, had I been on the juror, there is no way I could have been convinced that this man, with the clarity that he had, I could not have made the decision other than what the jury made. But
Sure.
still could not have
these
felt that he was sane without having mental issues.
Okay, go ahead.
Yes. Yeah. Yeah, good points, Ann. And these are really important issues to raise, that, yes, we want records as far back as possible, because knowing the history of the person and what led them to the point where they are in front of us today is really critical. And I think in the trial that you're referencing, the records did go back for several years, and I think we could all agree that we saw several really failures in the system when, unfortunately, the mental health system didn't intervene or minimally intervened, and it led to the tragic events that occurred. So we want to get as much information, as many records as possible to really fully understand the person, especially because when you are looking at insanity as opposed to competency, you are looking retrospectively at someone's state of mind in the past, a very difficult evaluation to do because you're looking at something that doesn't exist currently, it's in the past. And so you want as much information as you can, especially around the time of the crime, to be able to understand as much as someone possibly can about what someone was thinking and feeling and what was motivating them at the time of the crime. And I think it is really important to note that having a mental illness is not sufficient to either be incompetent or to be insane. In fact, most people with a mental illness, a serious mental illness, are both competent and insane. Insane. And so we have to really think about this as not a medical issue, but a very specific legal test, and particularly when we're looking at the insanity defense. So their state of mind at the time of the crime. The test is very strict, it's very narrow. So not only do you have to have symptoms of mental illness at the time of the crime that basically have to be impairing reality, but those symptoms also have to cause you to either not know what you were doing or that it was wrong. So again, we're looking at just a very narrow test, and I think some people conflate mental illness with the legal definition of either competency and insanity when they're really quite different.
Okay, and we're going to talk more about insanity here in a moment, but just with regard to competency, we know not long after Travis Reinking had been arrested, he was sent by Judge Fishburne to, I guess, referred to you guys, and then he spent 6 months at Middle Tennessee Mental Health. At some point, he was then deemed competent to stand trial, sent back to the jail here in Davidson County, and then stood trial just this last month. Now, in the case of Michael Cummings, and I want you to speak in general terms here, but he's been incarcerated now for about almost 3 years for charged with this horrible mass murder. And I know for a fact that they have been trying, as they did with Travis Reinking, to get him competent to stand trial. 3 years now, and they still have not been able to do it. They had a trial scheduled, for next month, and that's been permanently put on hold. So can you, just in general terms, if there's a situation where there's a suspect who cannot be deemed competent to stand trial, what happens in perpetuity? Does he just stay held until the day perhaps comes where he is deemed competent? How does that work?
Sure. I mean, I think most often what happens is that people actually go in and out of competency. So the classic example is somebody is evaluated. They go to the state hospital, they're medicated and treated, they improve in their functioning and their symptoms are reduced and they become competent to stand trial. They are then returned to the jail setting, which is not a great setting for people who are mentally ill. They tend to do much worse. They're more symptomatic in the jail setting. And the jail setting is often a place where people cannot be forced or required to take medication, and they stop taking medication. And so we often see this kind of ping pong effect where people are returned to jail, they stop their medication, they deteriorate, they become incompetent again. They have to go back to the hospital, and the same process happens in some defendants over and over again, many times before they can go to trial. So it's not that they're not becoming competent, it's that they're not staying competent for the most part.
So, meaning that in a case like this where it's permanently put on hold, they will continue trying to get an individual competent. They'll just keep trying until they determine it meets that threshold. If they can't meet that, as far as you know, does that mean that individual stays status quo until that changes?
Yeah, so it depends on the reason that they're incompetent. Of course, you can't go forward with any court proceedings if you're incompetent. Nothing can happen in court constitutionally if you're incompetent to stand trial. Now, there are certain conditions that make people incompetent to stand trial that are more permanent, that are not likely to change, that are not responsive to medication or treatment. For example, if someone has a dementia, and their dementia, their neurocognitive problems are causing them to be incompetent, it's not likely that that's going to reverse, nor is it likely that that's going to improve. It's probably going to get worse. So those people may be more likely to be what's called unrestorable or unlikely to ever become competent. Likewise, people who have an intellectual disability and their intellectual disability is the cause of their incompetence, a portion of those people are going to be permanently incompetent because they can never improve their ability to reason or think better because their deficits are due to an intellectual disability. So yes, in those cases in which the illness is irreversible and not likely to improve with treatment, the charges they have to be dismissed, and then the decision is made whether that person may meet commitment criteria to a hospital or an institution.
Oh, okay, and that's determined by you. That's interesting. So if eventually they can never be deemed competent because of maybe some of the factors you just said, then the charges, I guess, would be dismissed. A lot of people are going to say, well, does that mean they're going to go free? I guess the determination would be either to commit them or release them?
That's right. That's right. Yeah, we cannot permanently hold someone pre-trial if they're not likely to ever become competent. That is that if the courts decide that is accurate, that they're incompetent and not likely to become competent, we cannot hold them indefinitely. The charges do have to be dismissed at some point.
That does not mean they'd go free, though, necessarily.
If they met commitment criteria, they could be committed to a facility or institution. So the key thing is whether they met commitment criteria. I think most people would agree that they would try to get some type of services in place, whether it's commitment to an institution or not, so that people aren't just walking out the door without any services or resources in place.
Wow. Okay. Because you understand what I'm saying. I mean, there's no question in some of these cases the individual's the killer. We know it. There's no mystery there. I mean, I can't see, someone saying, well, he's not going to be deemed competent, so let's just let this person who slaughtered 8 people walk out the door. There's no way that would happen.
Right. And in most of the cases that we're talking about, the reason that they're incompetent is due to psychosis. So they have a disorder that causes them to have psychotic symptoms. The major disorder that people think of in this category is schizophrenia. And most people who have those symptoms, who have those disorders, that's what's making them incompetent. They do become competent because they do respond to treatment and medication. So it's very unlikely for someone who just has, for example, schizophrenia to be permanently incompetent and to have charges dismissed and released with these terrible situations that you've described. That is going to be more likely to happen, like I said, with the individuals who have dementia or cognitive problems or intellectual disabilities. But the cases that we're talking about, the issue is psychotic disorders, and they are likely to respond.
Gotcha. Great point. Listen, we'll take a break. When we come back, we'll take maybe some more calls, and we'll get a little bit more now into insanity and how that works. We'll be back with Dr. Kimberly Brown. Very interesting right after this. Stay with us.
This is a Storm 5 weather update. For weather on the go, download the Storm Shield app.